the Land Justice Mubiru held that the Trial on Indictments Act is silent as regards the consolidation of cases and criminal applications. Your Lordship, the Land Justice himself acknowledged it that in criminal cases and applications, we do not have consolidation. However, Your Lordship, where the legislature legislature intends to have a procedure, they will provide for it. Like in the Court of Appeal rules, we have consolidation of appeals. However, in this particular case, it was never intended that criminal cases would be consolidated. Your Lordship, it is our prayer that this application is bad in law and should be struck out it should be struck out because it has no legal basis. Your Lordship, joinder of cases, joinder of counts and parties has an impact, produces a totally different impact from that of consolidation, where joinder of counts and parties in criminal law produces a totally different impact. In this particular scenario, where the court, let's say where the court has ordered the joinder of parties and counts, we would have to go back to the lower court. Charge all the parties afresh in one charge sheet. Commit them, and then come back. Commit them. The files are just simply placed together under one folder, and we proceed. I reiterate my earlier prayers.
Much as to be counted on my time. My Lord, I am privileged that I was part of that appeal of Ssewanyana and Ssegirinya versus Uganda, which is cited. I just want to add one other case, my Lord. The case of Makumbi Moses versus Uganda. Makumbi Moses versus Uganda. It is a criminal appeal number 068 of 2021. 068 of 2021. We'll be able to avail the copy of that ruling, my Lord. We are going to serve them, my Lord, as usual. We are going to give them a copy, my Lord. My Lord, today. Today by closure of business. Yes, my Lord. Yes. My Lord, in that case, as I said, I was privileged to be part of. Yes, both actually. I was part of. My Lord, the principle was that for as long as the procedure and the law under which the appeal or application is brought is wrong, then there is no reason why court should even look at the merits and demerits of that appeal or application. So in reiterating what my brother submitted, is that, my Lord, this application should be disposed of at that point without going into its merits. and demerits. But that said, since court was of the view that we should submit on the merits of this application, my lord, then who are we, my lord, not to? My lord, I'll seem to be repeating what he said, but I'm making a different point. My submissions will start with, my lord, that the law of joinder of parties and counts is provided for under Section 23 and 24 of the Trial or Indictments Act. My lord, I don't want to go into details of the provisions of that section. Yes, my lord. So, my lord, that the above sections are inapplicable in this, in respect to the application before you. Maybe you have just me, my lord. Can I make my point again, my lord? Your brother to annexures B and E.
The charging section.
Most obliged, my lord. Most obliged, my lord. So, my lord, I think I've been disrupted a bit, but let me recompose myself. I would again refer you to paragraph 21. That point was made. Paragraph 21 of the article's affidavit in reply. It clearly shows that the parties are totally different. Yes, my lord. As I said, my lord, you a bit disrupted me a bit when I was doing my whatever. And then, my lord, paragraph 23 and 24 of his affidavit in reply, 23 and 24, clearly shows that these two cases were not in the same series of transactions. By virtue of the dates and how they were committed. And meaning that joining the two would cause a miscarriage of justice. And it should also be noted, my lord, that is not, yes, my lord, it's not only the series of transactions which are different, but the districts in which these offenses were committed are different, the dates, witnesses, and the facts are different. My lord, allow me say this, that the difference, my lord, senior brothers did submit on the case of Kazinda Geoffrey versus Uganda. However, the difference between the two cases is that, yes, my lord, is that whereas in the case of Kazinda Geoffrey, were committed by Kazinda himself, a period of time, and the same series, it is different from this one, my lord, from cases in this application. And therefore, my lord, I also refer you to paragraph 26 and 27 of Mr. Jatiko's affidavit in reply. Yes, my lord. Oh. my lord, most obliged, maybe 2 minutes. 2 minutes, my lord. I try to keep time, my lord. Okay, my lord. Okay, my lord.
Which paragraph?
My paragraph 26 and 27, which shows that if you join the two, it would cause a miscarriage of justice. Then, my lord, I just want to echo what my colleague said, that the effect of that is that it will delay, if court rules to the effect that the two cases should be joined, it will delay the process further, because we shall have to charge the two groups together on a separate, different charge sheet, commit them. Yes, my lord, but I also need to add that we also undergo a fresh pre-trial. It was not said by my colleague. But it's also important, my lord, to note that the other parties are not party to this application. The parties we want to be added, to be joined, are not part of this application. It will affect all parties, actually. It will affect the accused persons under Masaka CRB 605, which is before this court, and Masaka and Rengo CRB 203. Okay. I just, in 30 seconds, my lord, only 30 seconds. My lord, only 30 seconds. Only 30 seconds. Is a prosecutor. It's not true that Jatico is not part of this case, prosecution, because prosecution involves perusal of files, preparing papers, research, and even preparing committee papers. And it's part, it has been part of this. So you cannot say that Jatico is not part of this case. And then, my lord, terrorism. Most obliged, my lord. My lord, we take our submissions.
Argument that this application is alien to law, what our colleagues termed as a PO. Indeed, it's not a PO. It's a response to what we had raised, substantial. And our contention, my lord, is that the law is very clear on this. And this court enjoys wide discretionary powers to consolidate criminal files. My lord, it's the reason we cited the provisions of Section 33 of the Judicature Act, which gives wide discretionary powers, and our colleagues have not in any way touched that. They have not canvassed that particular provision. We also cited the provisions of Section 17 of the Judicature Act, which was also never canvassed. We take it that they are agreeing to our submissions on that particular matter. As to whether the application should have been grounded on Section 23 of the Judicature Act, it's neither here nor there, my lord. It's neither here nor there. It's a question of... I failed to make head and tail out of it.
Not here, not there.
It is semantics, my lord. It is semantics in that whether joinder or consolidation, it all means the same. Yeah. Whether joinder or consolidation, this is a foreign language. It's English. So they all amount to one thing, bringing it together, the two files and the counts. That's what it entails. And this court shouldn't consider semantics, should consider substance. And even if court was to be constrained to consider those extraneous matters like consolidation vis-a-vis joinder, they are extraneous in the sense that, my lord, these matters have been used interchangeably when dealing with management of case files. Yeah, it's basically about management of case files. So even if court is to be driven to that particular direction, my lord, I would submit that that issue of consolidation was adequately canvassed in the Kazinda case we earlier cited. And the court and the Constitutional Court considered the Constitution to be the supreme law guiding this, naturally. And the decision is very clear in Kazinda. Once the trial offends Article 28, court has to get a remedy. That is the bottom line. Once the trial, court arrives at a decision that the trial is likely to cause infringement on the rights enshrined in Article 28, of necessity, court must get a remedy. I'm glad our colleagues have not addressed you.
You are glad?
Yes, because they agree with that, because it's surely a constitutional matter. And I'm grateful to that they wouldn't go against.
My lord, objection, once it has not been raised in reply, it doesn't have to come up in rejoinder. So his hands are tied.
My lord, if I could be given time to proceed.
Most of that
It's eating into my time. So, my lord, I just want to conclude that very point, by referring you to the Kazinda case on page 33.
We already looked at it.
Yes, page 33, just making a point on this. Where,
Lord Mayor, that is a repetition.
no, it's not a repetition, my lord.
Because I want to read it.
Yeah, I'm not going to read it. I'm just bringing out the principle. Because here, after court arriving at a decision that numerous trials for offences similar in character amount to deprivation of the right of fair hearing and contravenes Article 28, court went ahead and said, needless to say that Article 2 provides for supremacy of the Constitution. So in other words, court was not oblivious of the fact that there are other provisions, like Section 23 of the Judicature Act, which they are making reference to. Court said no. What takes precedence is TIA, yes. I was talking on Section 28. So 23, which they talked about. No, 23 and 24 of TIA. My lord, in the charge of 29th September,
For us to be on the same page, let's make reference to the cases.
the case in Masaka, the one who would seek to join here, there are only two parties. And they are the ones who are applying to join, to be.
There is a third one. Is there a third party?
There's one they added.
Yes,
There are three parties. There are three parties.
There's one they added when they were commenting.
Counts and another one counts.
My lord,
But at least that is the summary that I've seen from the unless have something different.
my lord, you will have the occasion to look at the committee papers. When the matter was brought on 29th, there were only two, and the charge sheet has never been amended at that stage. So it was at the time of the committee that they purported to bring a third one.
But now you were taking into something that is not before me, and which was never raised during the reply. We are opening it up. And we give them an opportunity to also.
Let me rephrase it, my lord, in light of the facts you have brought out. He presented the picture as if there were so many other parties we are dragging into this case who are in the Masaka case, and they were not. That's not the case.
Did I get him right? I thought he's saying there are other people in the case before here
Yes?
who are not parties in the other one, and you're bringing in other people to join them.
No, once that file is consolidated with this one, those other counts will be specific and respect to our clients. They wouldn't affect the rest of the parties. That's how I would sum it up. As to the consequences of the consolidation, revisiting the whole process up to the pre-trial proceedings, it's again a frivolous argument with all due respect.
Don't be respectful because you are not respectful. Let's respect.
I'm sorry for the language I've used, but it is a common word. I didn't intend. I hold them in high regard. I respect them so much. I'm sorry, my colleagues. But my lord, the point I was raising, the argument is untenable. Yeah, it's untenable. Because they suggest that whether they are fundamental irregularities with the trial process being handled in a parallel manner, that one here, another one in Masaka, and is likely to offend Article 28, that because of that inconvenience, let us proceed with the trial which is likely to be a futile exercise, a nullity. That's exactly what happened in the Kazinda case. They proceeded with the matter, oblivious of all these issues, and in the end, the whole trial was nullified by the Constitutional Court. Does it help the state? Does it help the court which is taking its time to listen to us? Does it help the parties? Who does it serve? Does it serve the interests of justice? That's why we are raising it at the earliest, and we must be commended. Most obliged, my lord.
The summary. Whereas this court has powers to grant any remedy under Section 33 of the Judicature Act, those powers are exercised judiciously and within the law. For as long as there is no legal provision for such remedy, the Section 33 of the Judicature Act is immaterial. I would refer you to that case of Ssewanyana and Allen versus Uganda Criminal Appeal number 294. It was held in that respect, that court can only act where it has jurisdiction, and jurisdiction is the provision of the law. That's all.